am attorney bathan-lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes. Hello again, everyone. Welcome to our virtual classroom. What shall we talk about in this video? I want to talk about de facto corporations. What are de facto corporations? How does this differ from de jure corporation? So this is what I'm going to talk about in this video. So what is a de facto corporation? A de facto corporation is one that exists for all practical purposes as a corporation, but actually does not have a legal right to corporate existence as against the state. In other words, it is a corporation that has not complied with all the requirements for it to become a de jure corporation. But it has sufficiently complied to the point that it can be treated as a corporation against third persons. However, the state does not consider it as a corporation. How about a de jure corporation? What is a de jure corporation? A de jure corporation is one that has substantially complied with all the requirements that are asked for under your revised corporation code, and it was issued a certificate of incorporation by the state through your Securities and Exchange Commission. So a de jure corporation, for all legal intents and purposes, that is a corporation that has complied with all or substantially all of the requirements provided for by law and is treated as such by the state. So it might be confusing to determine what is a de facto corporation and how it differs from a de jure corporation. One important thing to remember is, for a de jure corporation, or that which legally exists in the eyes of the law, that is a corporation that has substantially complied with all the requirements provided for by law. While a de facto corporation, it has not substantially complied, but there is sufficient compliance. But even then, the state still does not recognize it as a corporation. However, it may still be considered a corporation as against third persons. So what are the requisites for one to be considered as a de facto corporation? First is that there must be a valid law under which the corporation is incorporated. Second, there must be a bona fide attempt to organize under such law. Third is the actual user or exercise in good faith of corporate powers conferred by that law. So if there is a corporation and it can be incorporated under the revised corporation code, then that is one requirement that is already fulfilled under de facto corporation. So you have now your revised corporation code under which a corporation may incorporate. Now let's move on to the second requisite. There must be a bona fide attempt to organize. A bona fide attempt to organize would mean that there was an attempt, a bona fide attempt to incorporate to become a de jure corporation. Again, what is a de jure corporation? That is a corporation that is registered with the Securities and Exchange Commission and given a certificate of incorporation because it has substantially complied with the requirements provided for by law. So the second requisite for a de facto corporation is that the incorporators actually attempted to organize. In other words, they have actually made the articles of incorporation and they have filed it with the Securities and Exchange Commission. Because now you can see that there was really a bona fide attempt to incorporate, to become a de jure corporation. Now you might ask, why will then it become a de facto corporation if there was a bona fide attempt to organize? or a bona fide attempt to incorporate. It becomes a de facto corporation because perhaps inadvertently, the Securities and Exchange Commission has issued a certificate of incorporation, but when you examine the articles of incorporation, there were defects in the incorporation that resulted to the corporation becoming a de facto corporation. What defects would result to a de facto corporation? Defects such as failure to state all the matters required under the revised corporation code, or when the number of incorporators is more than 15, or perhaps one of the incorporators there is not of legal age, or when it is found that the name of the corporation resembles another existing corporation's name, or perhaps the bylaws were filed late. So these defects would lead one corporation to become a de facto corporation if perhaps inadvertently the Securities and Exchange Commission may have overlooked these defects and issued them a certificate of incorporation. If you have watched my other videos on incorporation, I'll put the link down below. We have discussed that your Securities and Exchange Commission will have to go over the articles of incorporation and see if there is substantial compliance. But of course, there may be some inadvertence. They may have overlooked some matters required by law. Just like earlier, we said the corporation may have placed there more than 15 incorporators. Perhaps this was overlooked and still they were issued a certificate of incorporation. This defect will lead one corporation to become a de facto corporation. Remember, there must be a certificate of incorporation for one to become a de facto corporation. Because if there is no certificate of incorporation, then it cannot even be considered as a de facto corporation. More so, if the corporation does not have its articles of incorporation or has failed to register the articles of incorporation with the SEC, plus there is no certificate of incorporation issued by the SEC, again, that corporation cannot even be considered as a de facto corporation. The third requisite for one to become a de facto corporation is the exercise of corporate powers in good faith. In other words, the corporation or the members or stockholders of the corporation, its officers, its directors, actually were unaware of the defects of their corporation, and because they're unaware of the defects, they continued to exercise corporate powers. What happens if they are aware of the defects of their corporate existence but still continued on with exercising corporate powers? They cannot be considered as a de facto corporation. Because again, the third requisite for you to be considered as a de facto corporation is actual use of corporate powers in good faith. If you know of the defect, then you cannot be considered in good faith. So, quick recall, what are the requisites for a corporation to become a de facto corporation? Number one, there must be a valid law allowing the corporation to be created. Second, there must be a bona fide attempt to organize or to incorporate. And third, the user of corporate powers, actual user of corporate powers in good faith. So these three requisites must be present for a corporation to be considered as a de facto corporation. Now, why is it important to determine whether the corporation is de jure corporation or a de facto corporation or not a corporation at all, not even a de facto corporation? Because there are certain rights that may still be available to members or stockholders of a de facto corporation. Of course, for a de jure corporation, since that corporation has substantially complied with all the requirements provided for by law, that means that all the rights that are conferred upon it by the revised corporation code, they will be able to exercise. How about a de facto corporation? In terms of limited liability on the part of the stockholders, that will also be available to your stockholders in a de facto corporation. So whether de jure or de facto, the limited liability of stockholders would still become a privilege or a right even on the part of the stockholders. Of course, as we mentioned earlier on, the de facto corporation is for all purposes, all practical purposes, it is still considered a corporation as against third persons. That's why we said it will have to be determined whether it's de jure or de facto. Because if de jure, then it is a corporation not only as against third person, but even as against the state. But a de facto corporation, for all practical purposes, it is still considered as a corporation as against third persons, but not as against the state. Simply stated, your de facto and your de jure corporations are essentially the same as against third persons. The liabilities created by the de facto corporations out of the contracts that they have entered into will have the same binding effect as if it is a de jure corporation, again, as against third persons. Your de facto corporation is even taxed just like a de jure corporation. And as what I've mentioned earlier on, the stockholders in a de facto corporation also has limited liability, just like a de jure corporation. The only difference between the two is how the state regards them. The de jure corporation, the state is bound by its corporate existence. The state is bound to respect the corporate existence. But as for the de facto corporation, the state will not recognize it as such. It will not recognize it as a corporation. And as such, the state can oust it from the exercise of its powers and can even dissolve it. So what do we call this proceeding that may be initiated by the state to question the existence of such corporation? We call it the quo warranto proceeding. This is covered under Section 19 of your revised corporation code. Let us read Section 19. It says, the due incorporation of any corporation claiming in good faith to be a corporation under this code and its right to exercise corporate powers shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding. A quo warranto proceeding is a direct proceeding initiated by the state through the Solicitor General, the purpose of which is to look into the existence of the corporation, to look into whether such corporation can validly exist as such. Can a private party initiate a suit as against a corporation to attack its corporate existence? The answer is no. It must be the state who will bring a direct proceeding as against the corporation to directly attack the existence of such corporation. It cannot even be collaterally attacked by the state or by any private individual. The law is very clear on that. Your Section 19 clearly says that the corporate's existence cannot be inquired into collaterally. Now, what is an example of a collateral attack? For example, Mr. X has a debt with ABC Corporation. ABC Corporation is now trying to collect from Mr. X. Now, Mr. X has come to an information that there is a defect in the corporation. He looked into the articles of incorporation, and then he found out that there are more than 15 incorporators in the corporation, in ABC Corporation. Can he now say in a suit by ABC Corporation against Mr. X, because ABC Corporation is now trying to collect from Mr. X? Can Mr. X now say, no, I will not pay you because you are a de facto corporation. You actually do not legally exist in the eyes of the state. Can Mr. X do that? The answer is no, because that is now a collateral attack. He is now using the defect of ABC Corporation in an entirely different suit. And what suit is that? The suit to collect money from him. That is a collateral attack. And again, we said that your revised corporation code is very clear. For attacking a corporation's existence, it must be done directly by the state through a quo warranto proceeding. Why only the state? What is the reason behind this principle? It shall only be the state because it is the state's right that has been invaded, that has been usurped. Why? Because it is only the state who can grant you permission to become a corporation and not a private individual. And therefore, it should be the state who must commence or initiate a direct proceeding precisely for that purpose. Because if the state remains silent about certain corporations' de facto existence, then the law will not allow any private individual to use that as against a corporation. So that's it for this video. I hope I have made the concept simple and understandable. I hope you learned something from this video, and again, I will see you in the next. So if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.